Good afternoon and welcome to this latest Law Lab update. I saw quite a few familiar names on the list today, but if I've not worked with you before, my name is Ross Gale. I'm a senior solicitor in our employment law team. I'm joined by my colleague Gavin McQueen, an associate in the team, and he'll be too humble to say this himself, but he is increasingly an expert in employee use of AI, especially in litigation. So today we'll be assessing the state of play of AI in the workplace from an employment law perspective, examining the new risks and the unexpected trends. We'll then cover some of the most notable recent tribunal cases, drawing lessons and hopefully bringing some of the key legal points to life. So just before we get started, there are a few housekeeping points to remind you. As I say, please keep yourself on mute for the duration of the session. We are recording it, so this will be shared with you as soon as it's ready after. Do feel free to ask any questions using the chat function, and we'll hopefully have time at the end to pick those up. And we cannot give any specific legal advice on this call today, so if you do have any specific queries on this or anything else, do just get in touch with us or your usual Bernice Paul contacts. So without further ado, getting started, what is AI? What are we talking about? We've presumably all heard of AI, artificial intelligence, and we're increasingly having various interaction with it in our everyday life. In terms of what AI is, it's a form of general technology where the machine or software is learning from the data that's input into it, and it then analyzes this, and it can then predict patterns, including language, based on what it learns, improve its performance, and do so over time. The most common in work, ChatGPT, DeepSeek, artificial intelligence platforms like this are essentially very, very well-read word predictors. They work by one estimating what the likely next word in a pattern or a sentence is likely to be, and that's how you get your results. So this means AI is made up of two very important components. Firstly, there's the data that's input into it. This could be a variety of things, including text, audio, images, and video. And secondly, there's the algorithms. So these are the coding within the software that contains the instructions on how to perform the specific tasks and how to learn and produce an answer. We're seeing AI manifest in various different forms now, be that chatbots, ChatGPT, analysis tools, virtual assistants, and image and voice recognition software, and even now image and video creation softwares too. Given the prominence of AI, and we're increasingly seeing it being used in all parts of everyday life, it's filtering into the workplace, whether that's either through company authorized software or unofficial use by employees too, and we'll cover off both of those points today. So firstly, what about use of AI by employers in the workplace? There are a range of different AI-assisted tools now available for use, which can help employers to perform certain workplace functions. So far, the kind of main tasks we're seeing in an employment perspective is using AI in recruiting and in hiring. So AI can be used to generate job descriptions. This might have been quite a lengthy process previously, but now with some prompts and a description, a detailed job specification can be prepared quickly and then fine-tuned by the hiring manager. We're also using AI as virtual assistants or chatbots that can ask or answer questions about preliminary job qualifications, salary ranges, and the hiring process, potentially even in some cases rejecting candidates lacking certain defined requirements. AI can also be used in sourcing and screening prospective candidates, searching social media, and being a checker on qualifications, being used to screen candidates essentially. This could even include prioritizing certain CVs with certain keywords or qualifications. AI can also be used to rate an applicant's performance and aptitude tests, a video interview, and it can even conduct video and recorded interviews itself with analysis of responses, including facial movements, speech tone, and patterns. It's also been seen as useful in onboarding. Chatbots can be used to answer new employee questions, direct them to the appropriate resources, and provide increasingly interactive training, which can, of course, be more effective. Moving to the longer term, you've seen AI being used in performance management in relation to conduct and productivity. So we've seen AI used by employers to allocate tasks or shifts, to measure performance and determine who's being successful, to select individuals for promotion, to analyze productivity, and to monitor and track employee attendance, activities, behavior, things like that. There are a few other uses of AI too. We've seen AI being used to track employee retention, basically algorithms being used to predict which employees are likely to leave their role, taking into account a variety of contextual factors. We've also seen AI be used in redundancy situations to select employees as part of a redundancy process. That's, of course, going to come with some risks. And for automation and efficiency, taking over admin-heavy, repetitive tasks, or even for initial researching or summarizing tasks too. Lastly, it can also be used as a safety monitor. It can be used to monitor safety risks in a known working environment. Passing back across to Gab to think about some of the key risks that these raise.
Thanks very much, Ross. So yeah, Ross is there just touched on kind of where we're either seeing or see potential use for AI in the workplace. And with that use comes some specific risks. So I'm now going to cover off kind of the key risks from an employer perspective where using AI in the workplace. And I'll do so with reference to the Equality Act and also other legal protections that might come into play. Firstly, touching on discrimination. So really the primary concern with AI tools is that there's a lack of transparency in how they work and how they reach the output that they do. And so there's a danger that when employers are relying on AI, particularly when they're making decisions about recruitment or employee management, that the software gives effect to prejudices and biases which are hidden in the software. And that can then lead to discriminatory outcomes. In terms of AI tools and the risk of discrimination, the tools are really only as good as the information that's provided to them. And so depending on the available data set that we might have or the algorithms that are used, then AI recruiting tools, for example, might duplicate and proliferate past discriminatory practices. For example, where there was favouring of one group of individuals over another. So that's really the high level discrimination risk with using this kind of software. Turning specifically to some provisions of the Equality Act, I wanted to cover off where we see kind of real tangible risk with them. So firstly, turning to direct discrimination under Section 13 of the Equality Act. As most of you might know, direct discrimination occurs where an individual is treated less favourably than others because of their protected characteristics. So the protected characteristics can be things like age, sex, disability. That's kind of what we're talking about under the Equality Act. If the employer relies on AI tools recommendations, so for example, in a hiring process or where there's another selection needed, for example, redundancy, and the employer has no reason to think that it's been fed discriminatory data, it'd be difficult to establish that the candidate's protected characteristic was a material influence on the decision maker. So in direct discrimination claims, knowledge of the protected characteristic and that impacting the decision making is key. However, in our view, there is still a risk that direct discrimination might arise. So a combination of other personal information such as sickness absence, education, employment history, length of service, and seniority, these things taken together could effectively serve as a proxy for a protected characteristic. So for example, if an algorithm concluded that a certain combination of data points tended to identify a candidate as a woman, then it might determine that women were less likely to be high performers in a particular role than men and rely on that as a reason to reject a particular candidate. So it might not be necessarily as overt if there was an individual person making the decision, but there is clearly a risk from a direct discrimination perspective. And the other difficulty is really understanding the decision-making process of the software in those circumstances. The next kind of key risk under the Equality Act is indirect discrimination. So this is sometimes potentially a kind of harder claim to make out and a harder claim for employers to think about, but it's where an employer applies a provision, criterion, or practice to all staff or to a group of staff in a way which on the face of it doesn't appear discriminatory, so it applies equally to everyone. However, the application of that practice or policy puts people with a protected characteristic at a particular disadvantage compared to those without that protected characteristic. Turning to think about how that might apply in the AI context, there could be several issues. So touching on the point Ross spoke about around using assessment tools, where we have an automated assessment tool, that could potentially disadvantage candidates based on race. So research that's been done so far has indicated that facial recognition technology, which is being used to assess candidates in video interviews or to monitor attendance at work, doesn't work uniformly well for all skin colours. And so there's a risk of discriminatory outcomes where it maybe can't pick up facial prompts or it can't necessarily identify people. The other issue to think about is potentially selecting individuals for recruitment or promotion. So again, models might have inbuilt bias in relation to sex based on the underlying data that's being used. For example, if data from the previous 10 years was used around hiring and promotion practices, that might have an inherent bias based on the data if there was a lack of diversity in those decisions previously. In terms of indirect discrimination claims, it is possible to avoid liability in those cases by showing that the employer's actions were a proportionate means of achieving legitimate aim, and that's known as the objective justification defence. However, when it comes to justifying discriminatory decisions based on AI tools, there's likely to be an issue around transparency and the employer not having all the information available to understand and explain how the algorithm works. And so we see that as being a potential issue in terms of defending such claims where we can't really drill down into the core decision-making process of AI, especially where it's provided by a third-party provider. Turning next to harassment under the Equality Act. So we think there's a potential for harassment to occur if an AI tool results in an employee experiencing unwanted conduct related to a relevant protected characteristic. For something to constitute harassment, it has to either have the purpose or the effect of violating an individual's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. With AI, I think it's unrealistic that it's going to have the purpose of creating that effect, given that AI is acting autonomously in that. But we think it's likely that it could have the potential effect required for harassment to be made out. So an example of when that might happen, again, touching on facial recognition technology being used, that might be used in an interview tool. And again, it doesn't recognize facial movements, for example, of a person with a facial disability, or where speech isn't recognized for individuals with strong accents, potentially from a foreign background. That might then mean that the technology doesn't respond appropriately to the interviewee to allow them to proceed as they should, and that could then have the necessary effect for a harassment claim. Moving away from the Equality Act and towards a kind of more widely known protection, so the unfair dismissal protection. If AI tools are being used in decision-making processes, so whether that's around performance, whether it's around conduct things, then there is a risk of irrational or unfair decision-making. Again, like we said, with the equality protection, managers might not understand how the algorithm works, how to interpret and use any resulting data, or how the decision has been reached. And that can be particularly problematic where AI is forming the basis for important decisions. So, for example, dismissing an employee for a conduct issue, where there have been capability issues, for example, around performance or attendance, or potentially where it's been used in a redundancy exercise. And that does definitely create a risk of potential unfair dismissal claims. In terms of unfair dismissal protection, there are 5 fair reasons for dismissal. And again, there's potentially a risk that an AI tool might lead to dismissal, which is not due to one of the fair reasons. I've touched on it kind of briefly there, but talking about how it might be used in redundancy and it might be used for selection. There is a definite risk there around potentially selecting people for redundancy using AI. As most of you will be aware, generally redundancy selection is done based on underlying data, so objective criteria, and trying to score people on an equal basis. But again, if we're feeding that information into AI software, we don't necessarily know how the decision's been reached. And actually, there was something reported on this. So back in March 2022, it was reported that 3 employees had settled claims against the cosmetics company Estee Lauder after they were selected for redundancy, in part based on an automated video interview. So that could form part of an overall redundancy exercise in terms of scoring and how people are selected. And where you're using that AI, then there's a risk that it analyzes potentially answers unfairly. Turning next to constructive dismissal. So constructive dismissal occurs where an employee resigned in response to the conduct of their employer that effectively amounts to a repudiatory breach of contract. So it has to be quite a serious breach of contract to be at that level. Generally, what we see in terms of these claims is people relying on a breakdown of trust and confidence, and the employer acting in a way which effectively undermines that to a fundamental extent. In terms of the AI space, that might happen where decision making is delegated to AI and an employer can't explain that decision. Similarly, you might see it where job scopes are changed. So if we significantly introduce AI into the workplace, there could be changes to employees' terms and conditions. There could be changes to their responsibility and what they're expected to do. If that's done without consultation and is done in a way which expands or undermines employees' roles, then that could potentially constitute a breach of trust and confidence. There are also potential data protection issues with the use of AI software. So if we're talking about it in a recruitment context, we could be screening CVs or cover letters through AI, but actually in doing so, we're then potentially putting people's personal information into that software. The same might also be said where AI is used in the decision-making process and the information within that is not anonymized. So again, looking at, for example, a redundancy exercise, and we're putting employee details in. Consideration, therefore, needs to be given to the lawful basis for processing any personal data, but also data security and what measures are in place. So is this a AI software that's been set up purely for an employer and we kind of have control over the data, or is this a third-party provider where there's much less regulation over the content and where that's going? Generally, employers need to be wary about how that software is being used and avoiding personal data being input unless proper consideration is being given to data protection issues and data security. And lastly, just a more broad general piece touching on employee relations. I think really thought needs to be given to the impact that the introduction of AI might have on employee relations and on employee morale, particularly depending on the use cases being trialed. This could be seen as a very positive thing, and I think in a lot of cases it will be, but also need to think of the flip side of this, for example, where AI is potentially being used to automate elements of employees' roles. There might then be concerns from staff about whether their role actually remains viable long term. We see a lot of discussion about that and AI potentially replacing elements of the workforce. So there's definitely risk of people becoming unsettled there. Similarly, where AI is being used for monitoring of staff, consideration needs to be given in terms of the impact that may have on them and whether it's proportionate. So we've seen increasing discussion about AI software being used in terms of video monitoring to check on performance and efficiency, particularly in kind of manual work. So that's really something to think about. But generally on the employee relations piece, we would say that where employers are thinking about introducing measures or AI software, then an employer might want to consult with their staff about the use cases and the proposals before implementing anything to effectively give employees advance notice and to try and get their input. I'm going to hand over now back to Ross to talk about the implications of the use of AI by employees in the workplace.
Thanks, Gav. So firstly, employers and our clients are increasingly facing the reality that their staff are using AI at work, and whether that is sanctioned or not. This reminds me of that saying that the only healthy people are those that are not being tested. It seems like the inescapable spread of such tools means that they're being used, whether as employers you realize it or not. There was a recent study that showed, I think, 46% of all computer workers said that they were using AI, and even if they were told not to, they would continue to do so. I think this confirms for many what is already true anecdotally, that regardless of policies, regardless of rules, AI is now being used by employees for work purposes in almost every single workplace. I suppose this is really just the latest escalation in something that's been going on for a lot longer, and that's the long-standing issue of shadow AI, that being the unauthorized use of software or hardware by staff. So for employers, the risks of such unchecked usage are considerable. Use of approved AI tools that are vetted and secured by your IT department already comes with all the risks that Gav just mentioned. And these are, of course, only multiplied and increased when such use is covert. So, firstly, legal liability. Anyone who's used AI tools is aware of their limitations, at least for now, their disposition for hallucinations, and often for serving back to you an answer that's just a little bit too good to be true, a little bit too simple. However, as their standards are generally high, they can lull users into a false sense of security. Employees relying on AI tools without appropriate training and safeguards risk producing work that compromises quality and can lead to wider reputational damage and legal liability for work that's below standards. It can also lead to a loss of your USP. Non-organizational specific AI tools are unlikely to be able to match an organization's specific style and approach, leading to potentially jarring inconsistencies between outputs. As awareness of AI usage grows, more and more customers will become aware they can use online tools to check whether something has been generated by AI or not. I suppose, like being caught plagiarizing at school, customers and clients may pick up on this, leading to losses of trust and, at worst, allegations that a product or a service is not as advertised, or even that you're in breach of contract. There's also the data protection point that Gavin's mentioned. Unregulated use of insecure AI tools widens the disclosure of sensitive company information and the personal data of clients, customers, and colleagues to a greater extent. This presents a real danger of breaching data protection regulations and risking significant fines and reputational damage. There's also an increased cybercrime and breach of confidentiality risk too. Unsanctioned AI tools not only carry the risk of sensitive information being mistakenly disclosed, but being actively used for cybercrime. Bad faith actors who gain access to such information will potentially have the means available to blackmail a compromised organization, their clients, their customers, and even their employees. Leakage of sensitive information can also provide training for ever more convincing phishing and ransomware attacks too. Further, we've already seen the politicization of certain AI tools like DeepSeek, like Grok, and it's possible that the data inputted by unwitting employees could end up in controversy or being used for someone else's interests. There's also a risk associated with confidential or sensitive information being input into the system as well. Where this is unauthorized, the employer does not have control over where that data goes, and it could include a variety of confidential workplace information. Intellectual property too. So if an employee is feeding data into an AI tool, they could be inadvertently training that tool, shaping its knowledge base, even helping your competitors by sharing a company's IP with other users of the tool on an industrial scale. This this works both ways. So with the reciprocal prospect of your employees through AI tools inadvertently using IP of others that does not belong to them and exposing your IP to use by others too. In both cases, there is risks of legal challenge. And of course, there's also a risk of harassment of employees as well. Employees using software to generate images, content relating to other employees that's then being shared in workplace group chats, things like that. Again, this is another potential avenue of liability for employers where occurring in the course of employment. I think there's an added risk when it's sexual harassment, considering the new duty to take reasonable steps to prevent sexual harassment now in place since October last year too. With this all in mind, we're also seeing AI start to filter into the litigation arena as well. Quite simply, employees are using AI against their employers. We now fairly regularly see communications from an employee where AI has been used. Sometimes the employee even covers this by saying that they've taken legal advice from a family solicitor. We're first seeing this in grievances. So we're often seeing this in relation to grievances, be that drafting of the grievance or responding to the outcome. We're also seeing increasingly individuals who might be using it to get high-level legal advice against the company and then use very formal legal language that you're maybe slightly surprised that they're using. This then, of course, translates into legal claims as well. And we've seen more and more AI used in tribunal cases that we're acting in, usually with unrepresented litigants. They're then somehow generating very lengthy and frequent correspondence to us and to the tribunal, often in record time. This is at the moment creating a lot of extra time and cost when litigating claims, as there's often difficulty in deciphering the information in the communication, what's relevant and what's been added that maybe shouldn't have been. While claimants are often using this to submit lengthy communications, it's actually often legally incoherent. It refers to cases that are not relevant. It fails to set out the proper legal basis for allegations or claims. I've had cases recently where UK employees are referring to their rights under the US Constitution. We've also seen an increase in pressure at the tribunal as well. Tribunals have a real resourcing issue at the moment, and with this increased amount of communications, this is only going to get worse. Therefore, the level of intervention and input, say, for tribunals to address this is going to vary from region to region. Where AI is being used, either for litigation or in a grievance, there's again concern about the information that's actually been put into that AI system to formulate the grievance or to formulate the pleadings. The communications that we're seeing often refers to confidential information and processes about the company. There's a big concern that large volumes of information, including emails, have been put into some form of AI to get this content. We would therefore not be surprised if in the future we do see some more guidance from the Employment Tribunal and indeed across the entire UK legal system about the use of AI in these ways. Passing back across to Gav.
Thanks very much, Ross. So just before we kind of give you some guidance on best practice, wanted to briefly cover the legislative landscape and where things sit for that. There's clearly a need for awareness raising and training, and that is being recognised by legislators. In the EU, they introduced the AI Act, which was imposed from the 2nd of February 2025, and that included strict limits on the use of AI in the workplace, but also requires all those within organisations utilising AI to have enough technical knowledge to understand how it can be used safely. This knowledge is termed AI literacy and necessitates the capability to assess the opportunities and the risks of AI usage. While this will only apply to UK companies who are operating or selling in the EU, it does illustrate the growing comprehension of the risks employers face and the recognition of this by legislators. The UK obviously sits separately from the legislative agenda of the EU now, and we might be facing pressure to deregulate the technology sector from across the Atlantic, and so we might end up in a position where our legislation effectively diverges from the EU, and it might be a problem that employers have to deal with themselves. In terms of any legislation in the UK just now, in terms of the employment space. So there have been some attempts to introduce legislation in the UK on this point. Firstly, with the Artificial Intelligence Employment and Regulation Bill, and secondly, the Artificial Intelligence Regulation Bill. The first of those was published by the Trade Union Congress in April 2024, and the main purpose of that was to regulate the use of AI systems by employers in relation to workers, employees, and job seekers, effectively to protect their rights and interests in the workplace. That bill also provided trade union rights in relation to the use of AI systems by employers and is designed to enable the development of safe, secure, and fair AI systems in the employment field. However, it's effectively made no legislative progress, and so is kind of sitting by the sidelines just now. In terms of the second bill that I mentioned, so that was originally introduced into the House of Lords in November 2023. It did complete passage through the Lords on 10th of May 2024 and was sent to the House of Commons, but it then failed following prorogation of Parliament for the 2024 general election. It was reintroduced this year, so in March 2025, by Lord Holmes of Richmond, so a Conservative peer, as a private member's bill, and it's currently awaiting a second reading. In terms of that bill, so really what's set out in that is that the main purpose of it is the establishment of a central AI authority in the UK to oversee the regulatory approach. If the bill is enacted in its current form, then the AI authority would be responsible for, firstly, undertaking various coordination and monitoring functions, including conducting an AI gap analysis of current legislation, so looking at things like potentially product safety and collaboration on other regulatory development. It would have regard to the principles set out in the Trade Union Congress Bill and promote transparency and freedom from bias, and effectively ensure that the regulatory burden is proportionate to the risk of an AI system. It would also require AI developers to appoint an AI officer, and there would be obligations imposed on AI developers concerning transparency, labelling, and also respecting intellectual property rights. So it would be quite broad-reaching in terms of scope, and is seeking to reach a balance between regulation but also not stifling creativity in the sector. However, as it's a non-government bill, it's unlikely to pass in its current form, if at all. There has been more recent discussion about AI regulation in the UK and what that will look like, but so far there are no concrete steps in place. Given the current lack of specific legal regulation on it, then really employers need to have regard to the existing legal framework when using AI. So things like the Equality Act that I've already mentioned, the Employment Rights Act in terms of unfair dismissal, and then also the existing data protection legislation. And I'm going to pass over to Ross again now just to cover off current guidance on best practice if you are using AI.
Yes, so with all these risks that we've outlined, how can you actually address this? So in the first instance, I think it's actually useful just to be able to identify where AI is being used. So some of the things to look out for is use of particular AI typical words. So many AI generated texts are full of the same types of words that are not very often used in other contexts. These could be words like essential, impressive, or good examples, along with unusual emotive terms. And you should also be wary of Americanisms and excessive punctuation. I don't see anyone that uses punctuation quite like ChatGPT. There also tends to be repetitive sentence structure and phrasing in AI-generated text, as ultimately it's often based on a very limited prompt. It's not got that much information to work on, so it has to repeat this information again and again and again. There's often a lack of coherence as well, and not on maybe the first reading, but once you get really dug into it, there are likely to be factual errors, or often what I think is indicative is a lack of factual content that you think would otherwise be relevant. Again, because perhaps an employee has only put in a limited prompt, it doesn't have that much information to work from. So again, if it's missing factual content, again, this might be indicative of the use of AI. The language itself, it tends to be broad, it tends to be generic. Again, it tends to lack details or in-sentence examples. And there can also be writing errors and inconsistencies. Depending what they are, they can either be a hallmark of a genuinely written human text, or it can be a mark of AI being used in a less than optimal way. So moving through the employment life cycle, how can we tackle the issues raised by AI? So when it comes to job applicants, you might want to warn job applicants even that you will disqualify any applications that have been created using or substantially copied from the outset using AI, and that you're going to warn them that AI detection software is being used on their CVs. So this upfront would let you do so, but again, this is going to raise different issues because often AI scanning software means sharing personal sensitive data of the applicants with an external party. And again, from a data protection perspective, that has to be covered off. When it comes to your actual employees, When considering using AI in the workplace, it's recommended that you determine now and make clear how much, if at all, employees will be allowed to use AI to perform their work functions, that they're trained on any restrictions or limitations that you want to put in place on the use of AI, that you ensure AI input should be subject to rigorous review to avoid errors, and that where AI is used, it's cited, and that staff may require training on how to get the best inputs. You want to ensure that staff understand the legal risks of using AI in the workplace, but the potential employer liability that I mentioned, the inherent bias and limitations of certain AI tools, the possibility that it's going to provide you with inaccurate responses, and the potential for it to then disclose trade secrets and other confidential information of others or even of your own to other users. Data privacy policies will also apply to the use of AI. IT teams should be consulted about approved platforms, and employees should be careful when entering personal or business sensitive information into public tools. Ideally, you'd put a suitable policy in place which addresses the permitted and the prohibited uses of AI in the workplace, the use of AI in recruitment, in appraisals, promotion, how an employer can incorporate AI into its services or products, and how any contractual arrangements the employer has with third parties will address liability arising from the use of AI. I appreciate that is a lot to consider, and on the basis of the changes in this space, even in the last year, we could be having a very different conversation again in a year's time. But for now, we'll move on to our latest employment law updates from the recent cases before the Employment Tribunal. So the first I'll cover today is the case of GP against Spelthorne Borough Council 2025. In this case, an employee brought claims including disability discrimination following their dismissal. The employee was unrepresented when they lodged their claim, and at a case management preliminary hearing that was held in January 2023 to consider the next steps required to progress their case. At the preliminary hearing, it was agreed that what happened next should be a consideration of whether the claimant was disabled within the meaning of the Equality Act 2010 at the relevant times for the purposes of her discrimination claim, and that the claimant should provide specification of the specific acts of discrimination alleged and how they should be categorised under the Equality Act, i.e. were they direct discrimination, indirect discrimination, harassment, so on. Quite common specifications ordered. At that preliminary hearing, the tribunal identified that the relevant period for assessing the disability status of the claimant was between December 2019, when the first alleged act of discrimination was said to have occurred, and up to the 17th of January 2021, which was the date of the claimant's termination of employment. A further preliminary hearing was then held in May 2023. At the preliminary hearing, the employment judge determined that the employee had not been disabled during that relevant period, that being from the initial act of discrimination or alleged discrimination until the termination date. In making the decision, the tribunal relied on evidence from the claimant and information from the claimant's GP, as they commonly do. The tribunal was satisfied that the claimant's impairment had had an adverse effect on her day-to-day activities, but vitally was not satisfied that it had or was expected to have a long-term effect on the claimant. This was based on the impairment neither lasting or being likely to last over 12 months or more at the date of termination, and the impairment being unlikely to reoccur due to it being a reaction to a specific work situation that was not likely to reoccur either. On that basis, on the basis of the finding just on disability status, the Employment Tribunal dismissed the disability discrimination claims as the claimant did not satisfy the test for disability. They did so before the claims had been fully specified. And that does seem to make sense. Generally, a claim for disability discrimination, whatever its form, cannot progress if there is no disability in perception or in reality. However, the claimant appealed the decision to the Employment Appeal Tribunal on two grounds. Firstly, on the basis that the specified acts of alleged discrimination should have been identified first, before then making a decision on whether they were disabled under the Equality Act. The claimant also appealed on the basis that they argued the tribunal had misdirected itself in terms of the relevant period for assessing when disability status was in place. The claimant argued that instead the relevant period should have been longer. It should have been up to the point of her appeal rather than just to the point of her dismissal, so it should have been longer. The EAT dismissed this appeal. In relation to the first ground of appeal, the EAT accepted that for some types of claim, it's important the acts complained of are properly specified before then assessing the prospects of success. However, it determined that there was no hard-edged rule requiring a tribunal to consider such issues before then determining whether or not the employee had a protected characteristic in the first place. In the present case, the Employment Appeal Tribunal was satisfied that the tribunal had identified a clear time frame as the relevant period and was entitled to make a decision on the question of disability before going any further with the disability discrimination claims. On the second ground of appeal, the EIT was satisfied that the original tribunal had properly identified the relevant period. The tribunal noted that the relevant period for assessing disability in discriminatory dismissal cases normally ends at the time of dismissal, unless there are specific allegations of discrimination after this point. In this case, the Employment Appeal Tribunal was satisfied that neither the claimant's pleadings nor impact statement outlined any allegations that there was discrimination after the point of dismissal. The EAT accordingly held that the tribunal was correct to consider disability status up to the dismissal only and no further. So what does this all mean in practice? The case is quite a clear reminder of the importance of considering preliminary points in tribunal proceedings and of the tribunal's approach when assessing disability status and the relevant time period. Often, disability discrimination claims from unrepresented litigants are not fully specified. It's therefore helpful that the tribunal has made clear that they can consider the issue of disability status without these claims being fully specified, so long as the tribunal is satisfied that the relevant period for assessing this has been clearly identified. The determination of this preliminary issue at an early stage could allow for the resolution of the entire proceedings without the need for the significant time and costs of a full hearing, and even prior to the merits of the alleged discriminatory acts even being considered in full. In the second case that I'll cover, which is the Commissioners of HM Revenue and Customers against Taylor Services Limited and others, the employer employed workers on a 0-hour contract to work in poultry farms across the country. The employers provided a minibus to collect the workers from their homes and transport them to their daily assignment, with journeys often being incredibly long. Sometimes this meant they were collected in the middle of the night in order to reach the assignment site for working the next morning. Workers had a contractual right to be paid on an hourly basis for this travel. However, this was just at £2.50 per hour, with workers potentially spending up to 8 hours a day travelling on top of their normal working day. In 2020, HMRC decided that this travel time should be paid at the national minimum wage and issued notices of underpayment to the employers, totalling around £62,000 of wage arrears, plus additional penalties. The employers naturally challenged this at the Employment Tribunal, and this was originally dismissed. It was recognised that while the workers were not necessarily working in the conventional sense while they were travelling on the minibus, the level of control that the employers exerted over the employees during the journeys meant that this time was tantamount to time work. Indeed, the employer would dictate the mode of transport, the collection times, and even the route. The employers then appealed to the Employment Appeal Tribunal, arguing that the approach was not consistent with the Supreme Court and that the Employment Tribunal had not properly considered the regulations of the national minimum wage concerning travel time and whether this was classified as time work. And the EAT overturned the original decision. The EAT considered the meaning of work and held that time spent travelling was not time where the worker would otherwise be working and was therefore not time work. The fact that the workers were collected from their homes was key here. The EAT noted that the employers were required to travel to their premises first and then spend substantial times travelling to assignments, this would count as work time for national minimum wage purposes. But as that wasn't the case here, it didn't count. Applying the Supreme Court's approach, the EAT held that it was necessary to look at the national minimum wage regulations as a whole when considering the meaning of work. In its view, the drafter of the legislation did not consider travelling to be work. Accordingly, time spent just travelling would not be time work. The EAT considered that any injustice created by this provision and interpretation was ultimately a matter for Parliament instead. HMRC did subsequently appeal this to the Court of Appeal, which ultimately upheld the Employment Appeal Tribunal's decision that the workers were not actually working while travelling, as they were free to use this time as they pleased. So, what's the meaning of this case? It means that there is a general rule that travelling will be treated as time work where it's done when the worker would otherwise be working, i.e., he or she were not travelling, they'd be working. This exception applies. An exception applies even where the travel is to and from the worker's home to their place of work, or where travelling between a place of work or a place of assignment is carried out. In the court's view, the EAT was entitled to find that travel in this case was not during time in which the workers would otherwise have been working, and because there was no time limit on the travel included in the regulations, the employers failed. An appeal to the Supreme Court is ultimately still available to HMRC, with some speculating that they might bring an appeal forward, and it would be interesting to see their view. Passing across to Gav for the last couple of cases.
Thanks very much, Ross. So the next case I'm going to cover off is only a case of first instance, but I think it still reiterates an important point in terms of case law and unfair dismissal protection. So the case I'm speaking about is the case of Sinclair against More Blacks, More Dogs, More Irish Limited and Mr. A.M. Suleiman. So this was a claim by a bar manager raised at the Employment Tribunal, and it was for discrimination and also for unfair dismissal. Ms Sinclair had been employed at the bar since July 2022, and in 2023 a number of comments were made by the second respondent, Mr Suleiman, to the claimant. These related to her heritage, suggesting that she looked Aryan, or suggested that she otherwise had an association with Germany. In reality, the claimant had no connection with Germany. However, she interpreted the comments as suggesting that she was potentially racist or associated with Nazi ideology. The second respondent also made a comment relating to female managers directly to the claimant in this case. In terms of the progress of employment, so by June 2024, the claimant was unexpectedly removed from the all-staff group chat, and the following month, just one day before she was due to reach 2 years service, she was dismissed with immediate effect. The reason given for her dismissal was poor sales performance. However, upon review, the Employment Tribunal found that her sales figures were comparable to those of her colleagues, and actually there had been no prior warnings or evidence of any poor performance by the claimant. In terms of the timing of her dismissal, so in this case, Miss Sinclair had been dismissed just one day short of 2 years service. In these cases, the statutory notice period would take her beyond the required 2 years service for an unfair dismissal claim, and therefore the Employment Tribunal held that she had been unfairly, well, firstly, that she was protected by unfair dismissal provisions, but secondly, that she had been unfairly dismissed. Whilst this is only a first instant decision, like I said, the case is a reminder that an employee can still claim for unfair dismissal with less than 2 years service if their statutory notice period takes them past that 2-year mark. In this case, whilst there appeared to be no genuine concerns about performance, employers should ensure that staff with under 2 years service are managed effectively, and that if there are any issues with conduct, performance, or ongoing suitability for continued employment, then they're addressed throughout the 2-year qualifying period, and that any dismissal takes effect before the employee reaches 103 weeks of service. So that allows you not to factor in that statutory notice period. Given the potential changes coming with the Employment Rights Bill introduced by Labour, and the proposed change to make unfair dismissal protection a day one right, it's even more reason for employers to consider their probation monitoring processes to ensure that any issues of conduct or underperformance are addressed fully and timelessly at an early stage of an individual's employment. The case here also had discrimination allegations and they were upheld. And again, it's worth noting that whilst we're talking about minimum service for unfair dismissal here, there is no minimum service requirement for discrimination claims at the Employment Tribunal. The next case I'm going to touch on is the case of Argent Lafon against ARC Syndicate Management, and this is another Employment Appeal Tribunal case. In this case, an employee was a senior underwriter and he made disclosures to his employer in relation to an insurance claim that his work had received, which he thought was potentially fraudulent. After he had raised those concerns, the company evidenced that it took them seriously, so it spoke with them to get further information. It encouraged them to raise those concerns, and it did then investigate those concerns on a number of occasions, but ultimately found no evidence of fraud, as he was alleging. Despite that, the employee continued to raise these concerns to the company. He was later put on a performance improvement plan due to a failure to hit his performance targets, but the employee refused to engage with that performance improvement plan, believing it to be a retaliation in relation to his disclosures. Sometime after that, the employee was ultimately dismissed, firstly for his refusal to engage with the performance improvement plan, and also based on there being a breakdown of trust and confidence. He then raised this at the Employment Tribunal, raising claims of detriment on the grounds of whistleblowing, automatically unfair dismissal on the grounds of whistleblowing, and also ordinary unfair dismissal. When looking at this, the Employment Tribunal found that whilst he had made some protected disclosures at an early stage, his later statements were not protected under the law, and they gave helpful clarity saying that it wasn't reasonable for him to continue to hold his beliefs about the insurance claim after a full investigation by his employer, which had found otherwise. Therefore, the disclosures he was making did not satisfy the reasonable belief test. So there has to be a reasonable belief about the allegations being disclosed and these being true for disclosures to be protected. And that was part of the reason why his claims failed. The tribunal also concluded that the targets set by the performance improvement plan were unrealistic and they were in fact a detriment. However, it found that they weren't actually connected to his whistleblowing, and so the detriment claims failed. In terms of his dismissal, the tribunal was satisfied that the principal reason for dismissal was not any protected disclosures he made, and was instead because of his behaviour and performance after those. However, whilst the dismissal was not automatically unfair, the tribunal did find that it was unfair due to procedural issues. So there wasn't proper advance notice in terms of the allegation against him of a breakdown of trust and confidence. And also in terms of the performance improvement plan, the employer found that the targets were not achievable and should have really been reviewed throughout the process. The employee then appealed this decision to the Employment Appeal Tribunal, but he was ultimately unsuccessful. And in addition, his employer cross-appealed based on the fact that the tribunal had not considered the impact of the internal dismissal appeal process and the potential for that to cure any procedural defects. The employer's cross-appeal was ultimately successful, and so the unfair dismissal finding was set aside and the decision's been remitted to another tribunal for consideration. In terms of what we can learn from this case, so this case really gives some important guidance on whistleblowing claims, and that even where protected disclosures have actually been made, an employer can still take other action, for example, dismissal or implementation of a performance improvement process, just so long as there are very clear and separate reasons for doing so. In this case, the respondent could show that it was the claimant's ongoing behaviour related to the disclosures and his performance that were the reason for his treatment, rather than any actual protected disclosure that he did make. Where any concerns are raised and disciplinary or performance action follows, then it's really important that an employer has a clear and separate reason for such action, and that's also well documented. This was one of the key things here for the employer, that they had a clear record of the investigation they'd carried out, but also the steps they'd taken and why the performance improvement plan had been put in place. In addition, the case gives us some helpful guidance on the limits of protection for disclosures by employees, particularly where steps have already been taken to investigate those concerns and it's held that they're not well founded. In those circumstances, it might not be reasonable for an employee to continue to believe in the basis for their concern and to make further disclosures about that. And accordingly, those would sit out with the scope of protection. That is all the time we have got today to cover off our topic of AI and the various legal updates. Thanks very much to you all for joining. As Ross said at the beginning, we will be circulating a copy of the recording, and there will also be an Employment Lab update in writing issued to you. If you've got any specific questions that you'd like us to answer about the content of the session or any of the case updates, then do please feel free to get in touch with either Ross or I or your usual Burness Paul contact. And otherwise, I'd just like to wish you well and hope you have the rest of a good day. Thanks very much.